Case file number 078. When 28-year-old construction worker Tyler Hoffman tried to refinance what he believed was his inherited property, he discovered his stepmother had used a quiet title action to steal his father's $185,000 house right out from under him. But this wasn't just a simple property grab. This was a sophisticated 3-year fraud scheme that would ultimately expose a $230,000 theft attempt using forged documents, perjured court testimony, and manipulation of Wisconsin's legal system. I'm your family wealth detective, and I've analyzed over 200 cases of family financial betrayal. What makes this case particularly dangerous is how Vanessa Torres used her real estate expertise to exploit legal loopholes that most families don't even know exist. By the time Tyler realized what happened, she had already extracted $45,000 through a fraudulent home equity line of credit and was living in his father's house as the legal owner. If you're managing aging parents' finances, dealing with a blended family inheritance, or have step-parents in your family structure, this case will shock you. Drop a comment with your location and hit subscribe if you're serious about protecting your family's wealth, because what I'm about to show you could save your family hundreds of thousands of dollars. Here's what makes this case a masterclass in family financial crime. Vanessa didn't just forge a few documents. She orchestrated a systematic legal fraud using something called adverse possession claims, manipulated court service requirements, and exploited Tyler's grief period to execute what I call a quiet title heist. Most people have never heard of quiet title actions, but they're one of the most powerful legal tools for transferring property ownership. And in the wrong hands, they become weapons of financial destruction. The financial stakes here are staggering. Tyler's father, David, had purchased this 3-bedroom Bayview property for $185,000 in 2018. By 2024, when Tyler finally regained ownership, the property had appreciated to $195,000. But during those 3 stolen years, Vanessa had extracted $45,000 through fraudulent borrowing against the property. Add in Tyler's legal fees of $25,000, the emotional trauma, and 3 years of lost rental income, and we're looking at over $300,000 in total family wealth destruction. But here's what should terrify every family watching this. Tyler had advantages most victims don't have. He was young, financially stable, and had clear documentation of his father's intentions. He had contributed $15,000 toward the original down payment. Multiple neighbors heard his father explicitly promise him the inheritance, yet it still took him 3 years and $25,000 in legal fees to undo this fraud. Imagine if Tyler had been elderly, financially struggling, or didn't understand the legal system. This case exposes 3 critical vulnerabilities in American family wealth protection. First, how step-parents can exploit access to estate documents during grief periods. Second, how real estate professionals can weaponize their industry knowledge against family members. And third, how quiet title laws designed to resolve legitimate property disputes can be hijacked by sophisticated criminals. What you're about to learn isn't just Tyler's story. This is a systematic breakdown of how family financial predators operate, the specific legal weapons they use, and most importantly, the 3 protection strategies that could have prevented this entire nightmare. By the end of this analysis, you'll know exactly how to prevent quiet title fraud in your family, recognize the warning signs of step-parent financial manipulation, and understand why proper estate documentation isn't enough without active beneficiary oversight. The legal outcome here tells you everything about how serious these crimes are. When Tyler finally proved the fraud, Vanessa didn't just return the property. She was forced to pay $75,000 in damages, including punitive penalties for her perjured court testimony. The court found her actions so egregious that she barely avoided criminal prosecution by agreeing to the settlement terms. This wasn't a civil disagreement about inheritance. This was systematic fraud using forged documents and false legal claims. Here's what makes me your family wealth detective in cases like this. I don't just tell you what happened. I show you exactly how these crimes work, step by step, so you can protect your family from the same tactics. We're going to examine the forged gift deed Vanessa created. We're going to analyze how she manipulated court service requirements to obtain a default judgment. We're going to look at the forensic evidence that ultimately exposed her lies. Most importantly, we're going to turn this criminal case study into your family's wealth protection blueprint. Because Tyler's nightmare represents thousands of similar cases happening right now across America. Stepchildren losing family properties to manipulative step-parents, elderly parents being isolated from their adult children during document signings, real estate professionals using their expertise to defraud the families who trust them. This is Case File 078, and it's going to change how you think about family inheritance protection forever. Let's dive into exactly how Vanessa Torres almost got away with stealing Tyler Hoffman's family legacy, and why her sophisticated scheme ultimately crumbled under forensic investigation. To understand how this fraud succeeded for 3 years, we need to examine the family dynamics that created Tyler's vulnerability. This wasn't random crime. This was calculated exploitation of specific psychological and legal weaknesses that exist in thousands of American blended families right now. David Hoffman's story begins in 2018. Fresh from a divorce that had drained his finances and emotional reserves. At 52, he was starting over completely. The Bayview house represented more than just shelter. It was his declaration of independence, his fresh start, and most importantly, his son's future inheritance. David made this crystal clear to Tyler from day one. Tyler wasn't just living there occasionally during his construction apprenticeship. He was investing in his own future. Here's where most families make their first critical mistake. Tyler contributed $15,000 from his construction earnings toward the down payment. That's documented in bank records. But David never formalized Tyler's ownership interest through legal documentation. No promissory note, no written agreement, no deed showing partial ownership. This created what I call an informal inheritance expectation that became legally meaningless when David died. The psychological dynamics changed dramatically when Vanessa Torres entered the picture in 2019. She wasn't some random woman David met online. She was a licensed real estate professional with over a decade of experience in property transactions. She understood property law, title transfers, and estate planning better than most attorneys. This expertise, which should have protected David's family, became the weapon she used to destroy them. Let me explain the psychology of professional predator targeting. Vanessa didn't choose David randomly. She specifically sought out recently divorced men with valuable property and adult children from previous relationships. This targeting pattern appears in dozens of similar cases I've analyzed. The psychology is calculated. Divorced men in their 50s are emotionally vulnerable, financially concerned about security, and often feel guilty about disrupting their children's lives through divorce. Vanessa's courtship strategy exploited every one of these vulnerabilities. She praised David's parenting. She complimented his property investment skills. She expressed understanding about his financial struggles. Most critically, she positioned herself as Tyler's advocate, telling David how wonderful it was that he was securing Tyler's future through real estate ownership. This wasn't romance. This was reconnaissance. The whirlwind marriage timeline should have raised red flags that no one recognized. 6 months from introduction to wedding, immediate cohabitation in David's house, instant access to all financial documents and property records. Vanessa's real estate expertise gave her legitimate reasons to review mortgage documents, insurance policies, and property deeds. She was helping David optimize his property investment for Tyler's benefit. Here's where the family psychology becomes crucial to understanding the fraud. Tyler actually liked Vanessa initially. She demonstrated genuine knowledge about property appreciation in Bayview. She suggested legitimate home improvements that would increase the property's value. She spoke knowledgeably about Milwaukee's gentrification patterns and property tax implications. Tyler trusted her because her advice was actually sound professionally. This trust-building phase is critical in family financial crime. Vanessa spent 18 months establishing credibility before David's death. She fixed actual property issues. She negotiated better insurance rates. She advised on legitimate tax deductions. This wasn't just emotional manipulation. This was professional competence deliberately weaponized to build trust that would later enable theft. The vulnerability window opened when David suffered his fatal heart attack in January 2021. Tyler was devastated, working full-time in construction, and completely overwhelmed by funeral arrangements and grief. Vanessa immediately stepped forward with an offer that seemed genuinely helpful. "Let me handle the estate complexities while you focus on healing." This moment represents what I call the grief exploitation window in family financial crime. Victims are emotionally incapacitated, legally naive, and desperately grateful for professional help. Tyler had no experience with probate law, property transfers, or estate settlement. Vanessa had handled dozens of such transactions professionally. Her offer to manage the legal details seemed like a blessing. But here's what Tyler didn't understand about Wisconsin probate law. Even with a valid will clearly stating Tyler's inheritance rights, property doesn't transfer automatically. There are specific legal procedures, court filings, and title transfer requirements. During this transition period, property ownership exists in legal limbo. Vanessa understood this limbo period created opportunities for manipulation that Tyler couldn't even imagine. The psychological manipulation during grief is particularly insidious. Vanessa didn't immediately change anything about the property. She continued paying utilities, maintained the house, handled property taxes. To Tyler, this looked like responsible stewardship. He was actually grateful that someone was protecting his future inheritance while he processed his father's death. What Tyler couldn't see was Vanessa's systematic documentation preparation. She was photographing property improvements she claimed to have funded. She was creating false records of mortgage payments. She was researching Wisconsin's adverse possession statutes and quiet title procedures. While Tyler grieved, Vanessa was building her fraud case piece by piece. The mail redirection represented the first concrete step toward theft. In March 2021, Vanessa changed the property tax mailing address to her personal post office box, claiming this would streamline estate administration. Tyler didn't question this because it seemed administratively sensible. He was still living in his apartment, working construction jobs, and assumed all property-related mail should go to whoever was managing estate matters. This mail control gave Vanessa several critical advantages. Tyler stopped receiving property tax bills that would have shown ownership changes. He missed any court notices related to legal proceedings affecting the property. Most importantly, he remained unaware of any title company inquiries or legal challenges to his inheritance rights. Vanessa had effectively blinded Tyler to legal proceedings that would steal his inheritance. The credit report discovery in March 2023 represents Tyler's first recognition that something was fundamentally wrong. A $45,000 home equity line of credit against property he believed he owned. This wasn't just suspicious. This was legally impossible unless someone else held title to the property. When Tyler confronted Vanessa about the HELOC, her response revealed sophisticated psychological manipulation tactics. She didn't deny the loan. Instead, she framed it as temporary estate management, necessary to cover property maintenance and legal fees. She claimed Tyler would benefit ultimately because the money was being invested in property improvements that would increase his inheritance value. This response demonstrates what psychologists call gaslighting through complexity. Vanessa used Tyler's legal ignorance against him, creating plausible explanations for suspicious activities. She implied that Tyler's questions showed his lack of understanding about estate administration complexities. She positioned herself as the responsible adult handling sophisticated legal matters that Tyler couldn't comprehend. But Tyler's construction background had taught him to verify complex claims, especially those involving large amounts of money. His decision to contact Independence Title Company in November 2023 represents the moment when victim psychology shifted to investigative psychology. Tyler stopped accepting Vanessa's explanations and started demanding documented proof. This shift from trust to verification is crucial for every family watching this analysis. Tyler's fraud lasted 3 years because he trusted Vanessa's professional expertise and accepted her explanations for suspicious activities. The moment he demanded independent verification, Vanessa's entire scheme began unraveling. Now let's dissect exactly how Vanessa Torres executed what I consider one of the most sophisticated property theft schemes I've analyzed. This wasn't opportunistic crime. This was systematic legal fraud that exploited multiple weaknesses in Wisconsin's property law system. A quiet title action is a legal proceeding designed to resolve disputes about property ownership. Legitimate uses include clearing old liens, resolving boundary disputes, or establishing ownership when property records are incomplete or contradictory. The legal standard requires proving superior ownership rights through documented evidence and proper legal procedures. Vanessa's fraud began just 2 months after David's funeral, in March 2021. While Tyler was still processing grief and funeral expenses, she filed a verified petition in Milwaukee County Circuit Court claiming ownership of the Bayview property through adverse possession and continuous residence. Let me break down why this claim was legally absurd and criminally fraudulent. Adverse possession requires meeting specific legal criteria under Wisconsin Statute 893.25. The claimant must demonstrate actual, visible, open, notorious, exclusive, and continuous possession of property for at least 20 years, with hostile intent against the true owner's rights. Vanessa had lived in David's house for barely 18 months. Her adverse possession claim was legally impossible under Wisconsin law. But here's the criminal genius of her approach. Vanessa wasn't expecting to win based on adverse possession merits. She was exploiting the default judgment process that occurs when defendants fail to respond to legal proceedings. Her strategy depended on Tyler never receiving proper notice of the court case, allowing her to obtain judgment without defending her false claims. Under Wisconsin law, quiet title actions require service of process to all potentially interested parties. This means Tyler should have received certified mail or personal service of the legal documents. Instead, Vanessa deliberately had the court papers delivered to Tyler's previous address from 2018, where he hadn't lived for 3 years. This wasn't accidental. This was calculated manipulation of service requirements to prevent Tyler from defending his inheritance rights. The forged evidence Vanessa submitted to support her claim represents the most brazen aspect of her criminal scheme. She presented fabricated receipts showing mortgage payments dating back to 2019, before she had even met David. Bank records would later prove these payments were actually made by David from his personal accounts, not by Vanessa. The handwritten gift deed she submitted as evidence deserves special analysis, because it demonstrates sophisticated document fraud techniques. Vanessa claimed David had executed this deed during their marriage, transferring the property to her as a gift. However, forensic handwriting analysis would later prove the signature bore no resemblance to David's actual signature on file with Milwaukee County. More damning, the notarization on this supposed gift deed was fraudulent. The notary whose seal appeared on the document later testified she had never witnessed David's signature on any property transfer documents. This means Vanessa either forged the notarization herself or conspired with someone to create false notarized documents. The $30,000 in claimed property improvements represents another layer of her fraud. Vanessa submitted contractor estimates for work she claimed to have funded and completed. Investigation would later reveal these estimates were never converted to actual contracts. The work was never performed. The receipts were fabricated. She was claiming credit for property investments that existed only on paper. When Tyler failed to respond to the improperly served quiet title action, the court granted Vanessa's default judgment in June 2021. This judgment legally transferred ownership of the property from David's estate to Vanessa personally. On paper, she now owned Tyler's inheritance completely. The speed of this legal theft is breathtaking. 3 months from filing to ownership transfer, Tyler went from presumed heir to completely disinherited without ever knowing legal proceedings were happening. This timeline demonstrates why family beneficiaries need active monitoring systems for property-related legal proceedings. With legal ownership established through the fraudulent quiet title judgment, Vanessa immediately moved to extract financial value from the stolen property. The $45,000 home equity line of credit she obtained in September 2021 wasn't random spending money. This was systematic wealth extraction designed to maximize her financial gain before anyone discovered the fraud. Let me show you exactly how she spent the stolen $45,000, because this spending pattern reveals her criminal intent. $20,000 went to kitchen renovations at her previous property, not the Bayview house she had supposedly invested in. $15,000 funded a European vacation completely unrelated to any property maintenance. $10,000 served as a down payment on a new BMW. None of these expenditures benefited David's estate or the property she claimed to have improved. This spending pattern proves criminal intent under Wisconsin fraud statutes. Vanessa wasn't making legitimate property investments or covering estate expenses. She was systematically converting stolen property value into personal luxury purchases. The professional enablement aspect of this case reveals how real estate industry connections can facilitate fraud. Attorney Mitchell Rodriguez, who filed Vanessa's quiet title action, later claimed he was deceived by her fabricated documentation. However, basic due diligence should have revealed the suspicious timing and questionable evidence supporting her claims. If this case is helping you understand family financial crime, hit that like button. It helps me reach more families who need this education. Rodriguez's involvement raises questions about professional responsibility in property law cases. Should attorneys be required to independently verify adverse possession claims that seem legally impossible? Should there be enhanced due diligence requirements when quiet title actions involve recent deaths and potential inheritance disputes? The sophistication of Vanessa's scheme becomes clear when you understand how she exploited specific weaknesses in Wisconsin's legal system. She knew that default judgments were common in quiet title actions because many defendants don't understand the legal implications of property disputes. She understood that handwritten documents, while unusual, weren't automatically scrutinized by busy court clerks. Most importantly, she realized that most people, including Tyler, don't monitor court records for proceedings that might affect their property rights. Her real estate expertise gave her several unfair advantages in executing this fraud. She understood property law terminology well enough to file convincing legal documents. She knew which evidence would be required and how to fabricate it convincingly. She had professional connections who could process her fraudulent claims without intensive investigation. But the most insidious aspect of her crime was the timing. By filing just 2 months after David's death, she exploited Tyler's grief period when he was least capable of recognizing and responding to legal threats. This timing wasn't coincidental. It was calculated exploitation of predictable human psychology during family trauma. The mail redirection component of her fraud deserves special attention because it's so easily replicated by other family financial predators. By changing the property tax mailing address to her personal post office box, Vanessa blinded Tyler to any official notices about property ownership changes. Property tax bills would have shown her name as the legal owner. Court notices about potential challenges to the quiet title judgment would have alerted Tyler to legal proceedings. Credit monitoring alerts about new borrowing against the property would have warned him about the fraudulent HELOC. This information control gave Vanessa nearly 2 years of undetected ownership before Tyler accidentally discovered the HELOC through his credit report. During this period, she was legally free to extract equity, make property decisions, or even sell the property entirely. Tyler's inheritance was completely at her mercy. The criminal sophistication here extends to her understanding of the 6-month statute of limitations for challenging quiet title judgments in Wisconsin. Under state law, Tyler had only 6 months from the date of judgment to file legal challenges to the quiet title action. Since he never received proper notice of the proceedings, this deadline passed without his knowledge. By the time Tyler discovered the fraud in 2023, traditional legal remedies for challenging the judgment were no longer available. This statutory limitation is designed to provide finality to property disputes, but it becomes a weapon when combined with improper service of process. Vanessa's strategy depended on this legal technicality protecting her fraudulent judgment from future challenges. However, her criminal mistake was the perjured testimony and forged documentation. While the statute of limitations might protect defective service of process, it provides no protection against fraud-based challenges to court judgments. Tyler's attorney would later use the forged gift deed and fabricated evidence as grounds for challenging the judgment based on fraud exceptions to normal finality rules. The HELOC extraction timeline reveals Vanessa's escalating criminal behavior. She didn't immediately borrow against the property after obtaining the fraudulent title. She waited 3 months, probably to allow the quiet title judgment to become final and to establish a pattern of apparent ownership. This delay demonstrates planning and premeditation inconsistent with any claim of legitimate ownership confusion. When she finally applied for the home equity line of credit, she submitted the same fabricated documentation she had used in the quiet title action. Bank underwriters, focused on property value and borrower creditworthiness, didn't independently verify the legitimacy of her property acquisition. This allowed her to borrow $45,000 against property she had stolen through court fraud. The systematic nature of her spending reveals the criminal enterprise element of her scheme. This wasn't impulsive behavior or financial desperation. She methodically converted stolen property equity into personal assets designed to be difficult to recover or trace. Tyler's decision to contact Independence Title Company in November 2023 represents the turning point where victim psychology transformed into detective work. But what makes this investigation fascinating is how quickly professional title examination exposed Vanessa's elaborate fraud scheme. Katie Morrison, the senior title examiner assigned to Tyler's case, had 12 years of experience analyzing property ownership disputes. Within the first hour of reviewing the Bayview property records, she identified what she later called red flag patterns that immediately suggested fraud rather than legitimate ownership transfer. Title examination isn't just document review. It's forensic investigation designed to verify the legal chain of property ownership through multiple independent sources. Morrison's analysis began with county recorder records showing the original property purchase by David in 2018, followed by his death certificate in January 2021. Then the suspicious quiet title judgment in June 2021. The timeline alone created suspicion. Legitimate quiet title actions typically involve long-standing property disputes or complex ownership questions that develop over years. Vanessa's claim to have obtained superior ownership rights through adverse possession just months after David's death was legally implausible under Wisconsin law. Morrison's forensic methodology involved cross-referencing multiple databases to verify Vanessa's claims. County property tax records showed David as the sole taxpayer through his death. Utility records showed David as the sole account holder through January 2021. Insurance records listed David as the sole property owner and policyholder. None of these independent sources supported Vanessa's claim of shared or superior ownership during David's lifetime. The fabricated mortgage payment receipts presented particular challenges for forensic verification. Vanessa claimed to have made mortgage payments dating back to 2019, suggesting shared financial responsibility for the property. However, bank records subpoenaed during the investigation showed all mortgage payments came from David's personal checking account, not from any account associated with Vanessa. This discrepancy wasn't just suspicious. It was evidence of systematic document fraud. Vanessa had created false receipts, claiming credit for payments she never made, then submitted these fabricated documents as evidence in court proceedings. Under Wisconsin law, this constitutes perjury, fraud, and potentially conspiracy if others helped create the false documentation. The handwriting analysis component of Morrison's investigation deserves detailed examination because it demonstrates how forensic document examination can expose even sophisticated fraud. The supposed gift deed submitted by Vanessa included what appeared to be David's signature transferring the property to her during their marriage. Forensic handwriting comparison involves analyzing specific characteristics of authentic signatures against questioned documents. David's authentic signatures, available from property purchase documents, bank records, and government filings, showed consistent characteristics in letter formation, pressure patterns, and flow dynamics. The signature on Vanessa's gift deed bore no resemblance to David's authentic writing patterns. Letter formations were different, pressure patterns were inconsistent, flow dynamics suggested someone copying rather than naturally signing. The forensic handwriting expert concluded the questioned signature was inconsistent with authentic David Hoffman's signatures, with high probability of forgery. But the notarization fraud was even more damning. The notary whose seal appeared on the gift deed, Sandra Williams, maintained detailed records of all documents she had notarized. Her records showed no entry for any property transfer involving David Hoffman. When interviewed by investigators, Williams stated definitively that she had never witnessed David's signature on any real estate documents. This evidence proved Vanessa had either forged the notary seal herself or conspired with someone to create fraudulent notarized documents. Both scenarios represent serious felony crimes under Wisconsin law, with potential federal implications if mail or wire communications were used in the fraud scheme. The property improvement claims required different investigative techniques. Vanessa had submitted contractor estimates claiming $30,000 in improvements she had funded. Morrison's investigation involved contacting the contractors directly to verify whether estimates had been converted to actual contracts and completed work. Share this with anyone managing family finances, because this investigation process could protect your family from similar fraud schemes. The results were conclusive. None of the contractors had been hired to perform the claimed work. The estimates were legitimate, but they had been requested under false pretenses and never converted to actual projects. Vanessa was claiming credit for improvements that existed only on paper. Physical inspection of the Bayview property confirmed these findings. The claimed kitchen upgrades, bathroom renovations, and exterior improvements simply didn't exist. The property remained in essentially the same condition as when David had died, aside from routine maintenance. This evidence proved Vanessa had submitted fabricated claims about property investments to support her adverse possession assertion. Combined with the forged mortgage payment receipts, this established a pattern of systematic fraud designed to steal property through false court testimony. The HELOC investigation revealed the financial motivation behind Vanessa's fraud scheme. Bank records showed she had applied for the home equity line of credit just 3 months after obtaining the fraudulent quiet title judgment. The application included the same fabricated documentation she had submitted to the court. Tracing the $45,000 in borrowed funds exposed Vanessa's criminal spending pattern. $20,000 had been transferred to contractors working on her previous property, not the Bayview house. $15,000 had been spent on international travel unrelated to any property investment. $10,000 had served as a down payment on personal luxury purchases. This spending pattern proved criminal intent under Wisconsin fraud statutes. Vanessa wasn't using borrowed funds for legitimate property maintenance or estate expenses. She was systematically converting stolen property equity into personal assets. The breakthrough moment in Tyler's case came when Morrison discovered David's original will through his previous attorney. The will explicitly stated David's intention to leave the Bayview property to Tyler, contradicting Vanessa's claims about gift transfers during the marriage. Combined with bank records showing Tyler's $15,000 down payment contribution and testimony from neighbors who had witnessed David's explicit statements about Tyler's inheritance, the evidence overwhelmingly supported Tyler's superior claim to the property. Morrison's comprehensive investigation file, eventually spanning over 400 pages of documentation, created an insurmountable case against Vanessa's fraudulent ownership claims. The evidence included forged documents, fabricated receipts, perjured testimony, fraudulent notarization, false contractor claims, and systematic financial fraud. When Morrison presented her findings to Tyler's attorney, Jennifer Walsh, in March 2024, the case shifted from property dispute to criminal fraud investigation. The evidence was so overwhelming that Walsh immediately filed motions to set aside the fraudulent quiet title judgment based on fraud exceptions to normal finality rules. The legal strategy for overturning Vanessa's fraudulent quiet title judgment required navigating complex Wisconsin property law while proving systematic fraud to judicial standards. Tyler's attorney, Jennifer Walsh, faced the challenge of convincing a court to set aside a final judgment based on evidence that hadn't been available during the original proceedings. Walsh's legal approach focused on fraud exceptions to Wisconsin's statute of limitations for challenging quiet title judgments. Under normal circumstances, Tyler would have been barred from challenging the 2021 judgment because the 6-month limitation period had expired. However, Wisconsin law provides exceptions when judgments are obtained through fraud, perjury, or other criminal misconduct. The legal standard for fraud-based challenges requires proving several elements by clear and convincing evidence. The defendant must demonstrate that fraud was used to obtain the judgment. The fraud must have prevented the defendant from presenting their case. The defendant must show they acted with reasonable diligence once they discovered the fraud. Finally, the defendant must prove they have meritorious defenses that would have prevented the original judgment. Walsh's motion to set aside the quiet title judgment included over 200 pages of evidence documenting Vanessa's systematic fraud. The forged gift deed, fabricated mortgage payment receipts, false contractor claims, and perjured testimony created an overwhelming case for fraud-based relief from the judgment. The handwriting analysis proving David's signature was forged provided particularly compelling evidence. Courts are generally reluctant to set aside final judgments, but forged documents submitted as evidence represent clear grounds for judicial intervention. Vanessa's initial legal response attempted to characterize the evidence as civil disputes rather than criminal fraud. Her attorney argued that handwriting differences could reflect natural variation in David's signatures over time. The mortgage payment discrepancies were characterized as bookkeeping confusion rather than systematic fabrication. However, the notarization fraud proved impossible to explain away. Sandra Williams' testimony that she had never notarized any documents for David, combined with her detailed notary records, created undeniable evidence of document fraud. Vanessa couldn't provide any innocent explanation for how her gift deed contained fraudulent notarization. The HELOC evidence further undermined Vanessa's position. Her systematic conversion of borrowed funds into personal luxury purchases contradicted any claim of legitimate property investment or estate management. The spending pattern demonstrated criminal intent rather than good faith ownership confusion. Faced with overwhelming evidence and potential criminal prosecution, Vanessa agreed to settlement negotiations in April 2024. The alternative was criminal referral to the Milwaukee County District Attorney for prosecution under Wisconsin fraud statutes, with potential federal charges if mail or wire fraud could be proven. The settlement agreement reached in June 2024 required Vanessa to transfer the property back to Tyler through a quitclaim deed. She was also required to pay $75,000 in damages, including Tyler's attorney fees, investigative costs, and punitive damages for her fraudulent conduct. The $75,000 payment represented more than just compensation for Tyler's losses. It included punitive elements designed to deter similar fraud schemes and acknowledge the egregiousness of Vanessa's criminal conduct. The settlement also included provisions preventing Vanessa from making any future claims against the property or David's estate. Most importantly for Tyler, the settlement required Vanessa to cooperate with efforts to clear the property title of any clouds created by her fraudulent actions. This included providing corrective affidavits and supporting documentation to ensure Tyler could obtain clear title insurance for future transactions. The legal precedent established by Tyler's case has implications beyond his individual situation. The court's willingness to set aside a final quiet title judgment based on fraud evidence sends a clear message about the consequences of perjured testimony and forged documentation in property proceedings. Tyler regained legal ownership of his father's house in August 2024, nearly 4 years after David's death. The property had appreciated to $195,000 during the fraud period, representing financial recovery beyond the original inheritance value. Tyler's nightmare could have been prevented through 3 specific protection strategies that every family with property inheritance needs to implement immediately. These aren't complex legal maneuvers. These are practical safeguards that could save your family hundreds of thousands of dollars in legal fees and emotional trauma. Proper estate planning requires more than just writing a will. Your family needs active monitoring systems that alert beneficiaries to any legal proceedings affecting inherited property. Here's exactly what Tyler's family should have implemented after David's death. First, establish property alert monitoring through your county recorder's office. Most counties now offer electronic notification services that alert property owners to any filings affecting their real estate. These services typically cost less than $50 annually, but provide immediate notification of quiet title actions, lien filings, or ownership transfer attempts. Second, implement regular title searches as part of estate administration. Tyler should have ordered title searches every 6 months during the probate period to verify that property ownership remained unchanged. Professional title searches cost between $200 to $400, but can detect fraudulent ownership claims before they become legally binding. Third, establish mail forwarding protocols that protect beneficiaries from information control tactics. All property-related mail, including tax bills, insurance notices, and legal correspondence, should be forwarded to multiple family members. This prevents any single person from controlling information flow about estate assets. Fourth, require written documentation for all estate-related expenditures and property decisions. Vanessa's ability to extract $45,000 through the fraudulent HELOC could have been prevented if Tyler had required approval for any borrowing against estate property. Family members can't passively assume estate administration is proceeding honestly. Active oversight requires specific verification steps that would have exposed Vanessa's fraud within months rather than years. Beneficiaries must independently verify all claims about estate complications or legal requirements. When Vanessa claimed there were ongoing legal complications preventing property transfer, Tyler should have demanded specific court case numbers and documentation. Legitimate estate complications create public court records that beneficiaries can independently verify. Establish direct relationships with estate professionals rather than allowing single family members to control all professional communications. Tyler should have maintained direct contact with estate attorneys, tax preparers, and property insurance agents. This prevents family financial predators from creating false explanations for suspicious activities. Implement quarterly estate status reviews with written documentation. Every 3 months, estate administrators should provide written reports detailing all property transactions, legal proceedings, and financial activities affecting inherited assets. These reports should include specific documentation that beneficiaries can independently verify. Most importantly, never allow grief or family pressure to prevent verification of suspicious activities. Vanessa exploited Tyler's grief to discourage questions about her estate management. Family members must understand that protecting inheritance requires active skepticism, especially during emotional periods following deaths. Sophisticated property fraud requires sophisticated prevention measures that go beyond basic estate planning. Families need legal safeguards specifically designed to prevent quiet title fraud and property theft schemes. First, establish title insurance policies that specifically cover fraud-based ownership challenges. Standard title insurance might not cover ownership disputes that arise after the policy date. Enhanced fraud coverage protects against systematic schemes like Vanessa's quiet title manipulation. Second, implement professional fiduciary oversight for estate administration when family relationships create conflict potential. Independent fiduciaries, while expensive, provide professional property management without family loyalty conflicts that enable fraud. Third, establish legal requirements for major estate decisions that prevent single-person control of inherited property. Major transactions like refinancing, equity extraction, or ownership transfers should require written approval from all beneficiaries or their legal representatives. Fourth, create documentation systems that establish clear inheritance intentions during lifetime, rather than relying solely on wills. Tyler's case would have been much stronger if David had created formal documentation of Tyler's property investment and inheritance expectations while alive. Now let me show you the warning signs that could have alerted Tyler to Vanessa's fraud scheme years before he discovered the HELOC. Mail redirection requests during estate administration should trigger immediate verification requirements. When someone claims efficiency as the reason changing property tax or insurance mailing addresses, beneficiaries must independently verify that such changes are necessary and appropriate. Explanations of estate complexity that prevent beneficiaries from obtaining specific documentation about their inheritance should create suspicion rather than gratitude. Legitimate estate complications create specific legal proceedings with case numbers and court documentation that beneficiaries can review independently. Unexpected borrowing against inherited property represents an immediate red flag, requiring professional investigation. Tyler's discovery of the $45,000 HELOC should have triggered immediate title searches and legal consultation, rather than acceptance of Vanessa's explanations about temporary estate management. Professional credentials used to discourage beneficiary questions about estate administration often indicate exploitation rather than expertise. When Vanessa cited her real estate experience to explain away Tyler's concerns, she was using professional authority to prevent appropriate oversight of her activities. Changes in property tax billing or insurance policies without clear beneficiary notification suggest information control tactics designed to hide ownership manipulation. Tyler should have received independent notification of any changes affecting property he expected to inherit. Tyler's case has contributed to proposed reforms in Wisconsin's quiet title procedures that could prevent similar fraud schemes. These reforms include enhanced service requirements for family property disputes, mandatory waiting periods when property transfers occur shortly after deaths, and increased penalties for perjured testimony in property proceedings. The enhanced service requirements would prevent situations like Tyler's, where improper service enabled default judgments. Under proposed reforms, quiet title actions involving recent deaths would require service to all potential heirs through multiple methods, including certified mail, personal service, and publication in legal newspapers. Mandatory waiting periods would prevent immediate property transfers following deaths when inheritance disputes are most likely. The proposed 6-month waiting period would give family members time to understand their legal rights and respond to questionable ownership claims. Increased penalties for perjured testimony in property proceedings would create stronger deterrence against systematic fraud like Vanessa's scheme. Current penalties often treat property fraud as civil disputes rather than serious crimes deserving criminal prosecution. Beyond legal safeguards, families need communication protocols that prevent the isolation and information control that enables property theft. These protocols must be established before deaths occur, when family relationships are stable and everyone can participate in creating protection systems. Document all inheritance discussions with multiple witnesses present. David's verbal promises to Tyler about property inheritance became legally meaningful only because neighbors could testify about specific conversations. Written documentation of inheritance intentions, signed by multiple witnesses, creates much stronger legal protection. Establish regular family meetings about estate planning and property ownership that include all potential beneficiaries. These meetings should occur at least annually and should include specific discussions about property values, inheritance intentions, and legal documentation status. Create transparency requirements for anyone managing estate assets that include regular reporting to all beneficiaries. Monthly written reports detailing all property transactions, legal proceedings, and financial activities prevent the information control that enabled Vanessa's fraud. Most importantly, establish family policies that prioritize inheritance protection over interpersonal harmony. Tyler's initial gratitude for Vanessa's help prevented him from asking appropriate questions about estate administration. Families must understand that protecting inheritance requires potentially uncomfortable oversight of estate management. Tyler's ultimate victory represents more than financial recovery. Regaining his father's house restored his sense of family legacy and validated his father's intentions for his future. The hardwood floors David loved have been restored. The built-in sideboards that gave the house character have been preserved. Tyler has created both his home and his construction business headquarters in the space his father intended for him. But the psychological impact of 3 years of legal battles and $25,000 in attorney fees represents trauma that extends beyond financial measurements. Tyler describes feeling betrayed not just by Vanessa, but by legal systems that allowed sophisticated fraud to succeed for years, despite clear evidence of criminal conduct. The broader implications of Tyler's case extend to thousands of similar situations occurring across America right now. Stepchildren losing family properties to manipulative stepparents. Elderly parents being isolated from adult children during estate planning. Real estate professionals using their expertise to defraud families who trust them. Tyler has become an advocate for legislative reform and family protection education, speaking at legal conferences about his experience and working with estate planning attorneys to educate blended families about protecting inheritance rights. His message is simple. Proper legal documentation alone isn't enough without active beneficiary oversight and professional verification of suspicious activities. Based on Tyler's case analysis, every family watching this needs to implement immediate protection measures. First, establish property monitoring systems through your county recorder's office that will alert you to any filings affecting family real estate. Second, require written documentation and independent verification for any major estate decisions, especially those involving property transfers or borrowing against inherited assets. Third, create family communication protocols that prioritize inheritance protection over avoiding potentially uncomfortable conversations about estate management. The most sophisticated family financial predators exploit family politeness and grief to prevent appropriate oversight of their activities. Subscribe and ring the bell for more family wealth protection cases, and tell me in the comments, what family financial protection strategy will you implement first? Your answer could help other families recognize their own vulnerabilities before they become victims of sophisticated inheritance fraud. Tyler's story represents both a cautionary tale and a success story. The cautionary element shows how quickly and completely family wealth can be stolen through sophisticated legal manipulation. The success element demonstrates that even the most complex fraud schemes can be exposed and reversed through professional investigation and determined legal action. But the most important lesson from Case File 078 is prevention. Tyler's 3-year legal nightmare could have been prevented through active beneficiary oversight, professional verification requirements, and family communication protocols that prioritize wealth protection over interpersonal comfort. The $300,000 in total family wealth destruction Tyler experienced represents just one case among thousands of similar schemes operating across America right now. Every family with property inheritance, blended family dynamics, or aging parents managing valuable assets faces similar vulnerabilities to the ones Vanessa Torres exploited so successfully. As your family wealth detective, my mission is turning these criminal case studies into your family's protection blueprint. Tyler's nightmare becomes your education. Vanessa's sophisticated fraud techniques become warning signs you'll recognize immediately. The legal remedies that eventually restored Tyler's inheritance become preventive strategies that protect your family from ever experiencing similar betrayal. The forensic investigation that exposed Vanessa's lies demonstrates why professional expertise matters in family financial crime cases. Katie Morrison's title examination skills and Jennifer Walsh's legal strategy created the foundation for Tyler's ultimate victory. But professional help becomes necessary only when prevention systems fail. Your family's wealth protection depends on implementing the 3 strategies we've analyzed: estate documentation, verification, and monitoring systems, beneficiary active oversight and legal verification, and legal safeguards with professional verification requirements. These strategies, properly implemented, would have prevented Vanessa's entire fraud scheme from the beginning. Case file 078 is now closed, but Tyler Hoffman's story continues. He lives in his father's house, builds his construction business, and advocates for legislative reform that protects other families from experiencing his nightmare. The property that represents his father's love and his own financial future has been restored to its intended purpose. But across America right now, other families face similar threats from sophisticated financial predators who understand legal systems better than their victims. Other stepchildren risk losing inherited property to manipulative stepparents. Other grieving families trust professional credentials that mask criminal intent. Your family's protection depends on learning from Tyler's experience and implementing prevention strategies before you need them. Because by the time you discover family financial crime, the damage has usually been done, and recovery becomes expensive, time-consuming, and emotionally devastating. This is your family wealth detective, reminding you that the best defense against family financial crime is education, preparation, and the willingness to ask uncomfortable questions when family wealth is at stake. Stay vigilant, stay protected, and I'll see you in the next case file.